Welcome to participants from around the world to the third webinar in a series of regional launches for the Oxford Commentary on the 1970 UNESCO and 1995 UNIDROIT Convention, published by Oxford University Press last year. This Asian regional launch is organised under the auspices of the UNESCO Chair in International Law and Cultural Heritage at the University of Technology, Sydney, and we are grateful to the Asian Society of International Law for their support of this event, together with their sister organisations, the European Society of International Law and the American Society of International Law, for the regional launches in Europe and North America earlier this year. The regional webinar launches will also be planned for Oceania in early November and Latin America, Africa and the MENA in coming months. These regional launches coincide with the 55th anniversary of the adoption of the 1970 Convention and the 30th anniversary of the adoption of the UNIDROIT Convention concerning regulation of the trade in cultural objects and facilitating restitution claims, and the World Conference on Cultural Policies, Mondiacult, which is being held in Barcelona next week, which will emphasise the issue of illicit traffic and restitution as one of its major themes in the promotion of culture as a standalone sustainable development goal. History teaches us that the concerns around regulation of the art and antiquities market and multilateral efforts to address it are heavily informed by economics and economic power. This regional webinar launch, which focuses on Asia, is therefore important on multiple fronts to these debates and efforts. This event and the broader conversation we will be having is inspired by the publication, as I said, of the Oxford Commentary, which was co-edited by me and my dear colleagues, Drs. Andrzej Jakubowski and Alessandro Cecchi, and our panelists this evening all made important contributions to this volume. I am deeply grateful to them for giving of their time, knowledge and expertise for that publication and for joining us in this discussion. Before I introduce our first panellist, a bit of housekeeping. Panellists will be presenting for 10 minutes each. This will enable a Q&A at the end of the final panellist's presentation. Attendees are asked to pop their questions in to the panellists in the Q&A function, and these will be put to them at the end of the last presentation. The recording of this webinar and information about the program will be available on the UNESCO Chair website, links to which will be provided to participants after this event. Now let me turn to introducing Professor Lee. Let me begin by introducing him as the Professor of International Law at Seoul National University, Korea, where he has held numerous senior posts, including Vice President of Planning and Coordination. Professor Lee completed his law degree at Seoul National University and his Masters of Law at Georgetown University Law Centre, and undertook his doctoral studies at Cambridge University in the field of state succession in the post-decolonisation period. He has been a visiting professor and taught at numerous universities around the world. He was Director of Studies at the Hague Academy of International Law in 2010 and delivered its special lecture in 2018. Professor Lee is the Vice President of the Asian Society of International Law and President of the Korean Society of International Law. And significantly for public international lawyers amongst us, he is the elected member of the International Law Commission. Professor Lee has been legal advisor of the Korean delegation to numerous international conferences, including the 2003 Intangible Heritage Convention and the 2005 Convention on Cultural Diversity, and meetings of the Intergovernmental Committee on Restitution and Return at UNESCO, where he was chair in 2013 and 2014. And he, not surprisingly, has advised the Korean Foreign Ministry on a number of important returns to his home country. Professor Lee has long manifested a dedication to the promotion of culture in international law, particularly as it relates to movable heritage, restitution, and the addressing of the colonial past over many years. Welcome, Professor Lee. The floor is yours.
Thank you, Anna. Thank you very much for your kind words of introduction. And first of all, let me, well, hello, everyone. If I take the Seoul time as the standard, I should say good afternoon, because it is 5 p.m. over here, 5 p.m., 5 past 5 over here. But I know some of the participants are joining us from outside East Asia. So let me send my greetings, warm greetings to all of you by saying good morning and good evening, depending on where you are. joining me. Okay, first of all, I am very delighted to be part of this highly meaningful event and would like to begin by expressing my sincere thanks to Anna and the other co-editors of this Oxford commentary. So Professor Anna Filipa Wrodoliak and Andrzej Jakowski and Alessandro Kecki. And I'd like to also extend my thanks to the Asian Society of International Law for their support. And I'm very delighted to be participating in this panel together with my old friend, good old friend, Professor Kono and Professor Wang as well. Well, I was assigned about 10 minutes. And during this 10 minutes, let me address the following points. First, the changing landscape, as it were, surrounding the international cultural heritage law. Secondly, the significance of the publication of this Oxford commentary on the 1970 UNESCO Convention and the 1995 UNIDROIT Convention. Thirdly, let me briefly introduce the commentary I have worked on in collaboration with my wonderful colleague, Alessandro Kecki. That is Article 5 of the UNIDROIT Convention. I will conclude by offering my reflections on the importance of this book for Asia. Before going into these items, these topics, let me just briefly introduce you to these two conventions. Of course, time is quite limited, but at the same time, for those of you who are not quite familiar with these two conventions, and in particular the relationship between these conventions, let me be just brief and let me just provide some general information on the conventions. First of all, well, this Oxford commentary is commentary on not just one convention, one treaty, but two conventions. Why? Well, they are quite closely related to each other. So one can say that they complement each other. That's the reason why in this commentary, we are dealing with two conventions altogether. So the 1970 convention, the full title of this convention is Convention on the Means of Prohibiting and Preventing the Illicit Import, Export, and Transfer of Ownership of cultural property. It's quite a mouthful. But anyhow, it was adopted in November 1970, entering into force 2 years later in April 1972. And currently it has 148 parties. And then the 1995 convention, UNIDROIT Convention, the full title is UNIDROIT Convention on Stolen or Illegally Exported Cultural Objects. It was adopted in June 1995, entering into force 3 years later on July 1st, 1998. And currently it has 56 contracting states. And I already said that these two conventions are in a relationship of complementarity. So the 1970 convention, well, it provides very important principles and kind of framework on this question. That is the prevention of illicit trafficking in cultural objects. But at the same time, it is lacking in specificity. And this lack was addressed. This, let's say, quote unquote, lack was addressed by the 1995 UNIDROIT Convention. So one can say that the 1995 Convention fleshes out, as it were, some parts of the 1970 Convention. So that's the reason why they constitute together a functional unity or functional whole. That's the reason why you see again, in this commentary, these two conventions are being addressed at the same time. Okay, then let me go on to the kind of, the background against which this important commentary has been published. So let me just address very briefly the changing landscape of the international cultural heritage law. Well, about 40 in the 1960s or the 1970s, and there were some pioneers of research in this field. There was a rather small number of them, but at the same time, there were some quite outstanding Australians, the compatriot of Hannah, Linda Prout and Patrick O'Keefe. They really conducted pioneering research in this field. And when they started out in this field, they say that it was their research was kind of outcry in the wilderness. I think I heard them using that expression. But now you can see that this outcry in the wilderness has turned into a resounding thunder. So now this topic, the field of international cultural heritage law, has become quite is attracting lots of attention, right? So, for instance, the prevention of illegal trafficking in cultural objects, and a rather cognate question of the return of cultural objects to their countries of origin, and some of these topics. If you open your newspaper, or maybe you could check your newspaper news information on your cell phone, then quite often you encounter the cases of these relating to the return of cultural objects. So it has resulted, this development have resulted in the heightening of public awareness of these questions, and also it has led to a substantial increase in state practice. In particular, a growing number of court cases are relating to these questions. So that's the reason why one can say that the expression international cultural heritage law has firmly acquired its citizenship, as it were, in the discipline of international law. So this was eloquently demonstrated by the publication of another important book titled The Oxford Handbook of International Cultural Heritage Law, which was published 5 years ago, 2020. So it is against this such background that this commentary was published early last year. And let me go on to the significance of the publication of this commentary. Again, a bit of history, prior history. As I said to you, some pioneering research was conducted by researchers like Patrick O'Keefe and Linda Prout. I'm mentioning their names because they published their own commentaries on the 1970 Convention and the 1995 UNIDROIT Convention, respectively. They are both second editions in 2007 and 2021, respectively. But I can say that the Oxford commentary builds and expands on their work substantially. The fact that, and I'd like to emphasize that, the fact that it is published by one of the leading publishers, Oxford University Press, signals that the field of international cultural heritage law has joined the mainstream of the discipline of international law. And the commentary runs to almost 1,000 pages. This reflects that in the 30 or 40 years, there has been growing state practice, including a number of court cases, to be incorporated into the commentary. And also, if you open up this book, there you can find the list of authors, contributors. So you can find that a large number of researchers studying the issues, and they are approaching this issue not only from public international law, but also from private international law and comparative law as well. So the publication of the commentary will provide much assistance to the practitioners and scholars alike, and it will further strengthen the academic status and citizenship of the discipline of international cultural heritage law. Well, I think my time is almost up, so I think I'd like to urge you to read Article 5 of the UNIDROIT Convention, the commentary of which, for the commentary of which I worked with Alessandro, and this is one of the quite important. Of course, other provisions are very important, but at the same time, this is one of the key provisions of the UNIDROIT Convention. So I'd like to urge you to read that, read and enjoy the commentary to Article 5. And let me just conclude by saying just a few words. Well, I'm 5 years ago, I contributed a chapter on Asia for the book co-edited by Anna, and the title of the book was Oxford Handbook on International Cultural Heritage Law. So, yeah, well, these days, I'm making these concluding remarks in connection with Asia by paying attention to Asia. These days, one often hears about the rise of Asia in international relations. This is by the way, I'm reading out from the last paragraph that I included in my contribution to the 2020 handbook. This rise generally discussed in economic. This rise generally discussed in economic and military terms. For the rise of Asia to be fully acceptable and even welcomed by the international community, it needs to take place at the cultural and moral dimension as well. If the countries in the Asian region assumed a more active and exemplary role in the protection of cultural heritage by, among others, putting in place a more robust institutional mechanisms for regional collaboration and promoting international cooperation through a stronger commitment to international treaties and instruments, particularly the UNESCO conventions, it would be instrumental for its rise to be taken as constructive for the common good of the international community. So I think especially Asia has quite a number of problems relating to the protection of cultural heritage. So I think the publication of this handbook, this commentary, will be quite instrumental for Asia to address this problem. And well, I'd like to thank you for your kind attention, and I'd like to extend my sincere thanks to and congratulations to Anna for her wonderful work. Thank you.
Thank you very much, Professor Lee. And I will say that the congratulations is to the team effort. It's many contributors from around the world, and I'm very grateful to you all. It wouldn't have been realised otherwise. And your intervention has also reminded me of the debt that we all owe to Professor Francioni, the late Professor Francioni, who his commentary on the World Heritage Convention inspired this series that was taken up by Oxford University Press on a commentary for all the UNESCO Culture Conventions. The idea being to gather together the state practice on those conventions and to bootstrap them in what they are trying to achieve. So hopefully this is one of those steps forward in that, and we owe him a great deal of debt of thanks, including to those scholars that you mentioned, Lyndall Prott, Patrick O'Keefe. I'm thinking of Professor Shilon as well, who passed away before we were able to finish that volume. The other thing that you mentioned is your contribution to the handbook, and it's a wonderful reminder, and I will ask the publisher, where I'm seeking to prepare a dedicated web page on the UNESCO chair site of all of these recordings of the regional launches, and maybe there is also the introductory chapter to the commentary, but I will ask if we can also include the relevant segments for the regional practice that you mentioned, including Asia, for this launch. It would be very important for those that are wanting to have access to that. So thank you very much, Professor Lee. I will now move on to Professor Cornell, although this wasn't under intended sequencing of events, but because of the technological issues around getting Professor Wong coming into to the webinar, we will have Professor Cornell next. So welcome, Professor Cornell. Professor Cornell is the Emeritus Professor of Private International Law at Kyushu University in Japan. He holds a law degree and a Master of Law from Kyoto University. He holds numerous leadership positions in private international law, scholarly societies in Japan and internationally, including President of the International Academy of Commercial and Consumer Law and Chair of the International Law Association's Committee for Intellectual Property and Private Law, and is a member of the International Academy of Comparative Law and a board member of the Japanese Association of Private International Law. Professor Cornell's commitment to and expertise in the legal protection of culture is broad, deep and long-standing and is internationally recognised. He was part of the UNESCO's expert group involved in the drafting of the Intangible Heritage Convention and the Convention on Cultural Diversity. He's a member of the governing board of the UNESCO CAT2 Centre on International Research Centre of Intangible Cultural Heritage in the Asia-Pacific region in Japan. His important research on intellectual property in the area of intellectual property was reflected in the chairing of the ILA committee. His leadership in the World Heritage protection was manifest during his presidency of the International Council of Monuments and Sites, ICOMOS, an advisory body under the World Heritage Convention, at a crucial and productive period for that organisation. He has been involved in the promotion of the regulation of the trade in cultural goods and facilitation of claims for restitution through his work with UNIDROIT. His leadership and scholarship has rightly been recognised by international awards, including the Raimo Luster Award for International Scholarship and Cultural Exchange. Professor Cornell, thank you for accepting my invitation and welcome.
Thank you. Thank you very much for your very kind introduction. Good morning, or good afternoon, or good evening, participants. It is my great honor and pleasure to be with you, and I'd like to share some thoughts about the book and cultural heritage law with you. As Professor E mentioned already in his lecture, this book covers two conventions. This is, well, it looks maybe unusual for some readers, but it is very, very significant. This is very, very significant. I come back to the point a little bit later. Also Professor E mentioned two great Australian scholars, Leonard Prott and Patrick O'Keefe. They drafted a commentary also for each conventions. The Patrick wrote about 1970 convention, and the Lindell wrote 1995 UNIDROIT Convention. So these are the standard, these have been standard works for those who like to explore this field of law. But it is explained here and there in their books, but it is not so clearly, let's say, demonstrated that these two conventions are complementary. One is international framework, another is focusing on civil litigation, and civil litigation as a tool for the return, and this to overcome the different property laws in different jurisdictions. But to put these conventions together and give more detailed explanations is extremely important as a new step of this field. This said, I would like to emphasize that the importance also the chapter or the parts which deals with different conventions. This is the part 4. Part 2 is the commentaries on 1970 convention, and part 3 is the 1995 conventions, and the part 4 deals with different conventions. And this is, I think, very, very important aspect of this publication. Let me cite just a part of the decision of the World Heritage Committee. This was a committee decision in 2018, and about the Naumburg Cathedral, and about the Criterion 1, masterpiece. And the committee decided so, quote, these are they are sculpted from the same blocks of stone as the pillar strips, and the various media are integrated in a fabric of the architecture and its manner of construction. A single intelligence stood behind the integrated conception of the architecture, sculpture, and stained glass, and merged them into one integral piece of work, quote, end. So this is the explanation of the Criterion 1. So you can understand that not only the architecture of the cathedral, but also sculptures and stained glasses are considered as a part of outstanding universal value. So you see the movables integrated in immovables, and it become a heritage site with outstanding universal value. And this, of course, this can be debated, but this decision is made. So now we should understand that we are now live in a world where different cultural categories should keep separated. Now we should rather move to our next stage. For instance, well, as this commentary covers 2003 conventions intangible cultural heritage, so it was not known until 2000 when this convention was adopted for in many jurisdictions. When I was explaining, that was 2001 or 2, when I was explaining what I've been doing at UNESCO to my European colleagues about intangible cultural heritage, and the first reaction was, "What is this?" So they didn't understand what intangible cultural heritage was. So now it's a part of the field. So the evolution, development of heritage studies are inevitably have been inevitably combined with the let's say elaboration of heritage categories. So the tangible, intangible, movable, immovable, and also among tangible heritage categories, there are new developments. Recently, ICOMOS established an international scientific committee on space heritage. So this sort of evolution will continue. But on the other hand, some people started to recognize that we have been losing something through this categorization and elaboration of categories. So now this is also my viewpoint. We need besides this evolution, we need more, let's say, comprehensive horizontal approach, and I name it a heritage ecosystem. And so it is highly important to keep the let's say pluralistic perspectives, and also for the law. Let's focus on the law. Let's say when I was a student, I was taught that the international law is deals with the state relationship, while the private law has nothing to do with that. But this division might be questioned. For instance, in the field of international environmental law, the court could easily cite international instruments, soft law or hard law, to make a company liable for the loss or the damages. So this state-to-state relationship and the private-to-private relationship now maybe getting closer. So in this context, I remind you that this book combines two conventions, 1970 conventions, 1995 conventions. One is international framework, one is civil litigation, but they put together. This is a fabulous, fabulous aspect. And also, from the liability perspective, the classical, let's say, civil private law approach is based on individual liability, but it was further developed for organizational liability or responsibility. But now we should think about network liability. Supply chain is a network. And the transaction of cultural properties is also a network. There's a source country, there's a market country, there's also somebody in the middle. So it is very simplified, but still you have three parties. And it could be more complicated, right? So if you approach this from the network perspective, then the legal role of gatekeepers could be seen differently. So we need a new approach for the law as well. So to put everything together, this book already shows this approach. Okay, two conventions are together, and also it covers other conventions with multiple lenses, through the multiple lenses. So I think this is a great milestone for a new start. I stop here. Thank you very much.
Thank you. Thank you so much, Professor Kono. I've been taking notes, and I'm one of the editors of this commentary about what we need to do to improve it when it's the next edition. And I'm also reminded, because I am reminded of the wonderful contribution of Professor Patrizia Vini about the overlap with underwater cultural heritage. And we know that Patrick O'Keefe was involved in the drafting of that, as were a number of other colleagues, even on this call, on this webinar. So thank you very much, Professor Corno, and I look forward to discussing those important points that you've made now during our webinar and going into the future as well. So thank you again, Professor Corno, and now I'd like to welcome our final panelist, Professor Wong. Professor Wong Yungxia is the Distinguished Professor of Legal History and a UNESCO Chair at the Renmin University of China in Beijing. She's also the Director of Cultural Heritage Law at the Cultural Heritage Law Institute. As if this wasn't enough, Professor Wong is also a Distinguished Professor at Minzu University of China. She completed her law degree at East China University of Political Science and Law in Shanghai and her doctoral studies at Renmin Law School. Professor Wong has been an invited speaker at numerous international conferences in Europe, Asia, and Oceania on the topic of cultural heritage law, particularly restitution of cultural objects. Professor Wong has held many leadership roles in the field of legal history, including Vice Director of the Legal Culture Research Centre at Renmin University, Executive Member of the National Institute of Foreign Legal History, and she has rightly received national awards for important scholarship, including the first prize for the first National Legal Cultural Research Achievement Award. Professor Wong has contributed to the effective regulation of cultural objects nationally and through multilateral efforts for many decades. We are privileged to have her be a foundation collaborator, the UNESCO Chair. Professor Wong, thank you for accepting this invitation and welcome.
Thank you. Thank you very much, Anna. I'm terribly sorry for my late login. There is some severe problem for me to get in this room. Finally, anyway, I got in. Compared to Professor Kunu's perspective, and my focus is only on China. So So let me start. It's my great pleasure to attend such an extraordinary event. I'm deeply honored to be one of the authors of this book and to collaborate with so many world-class scholars. I've learned a great deal from my co-authors and editors like Professor Gustamblis and you, Anna. Today, I'm going to talk about the significance of the conventions in combating illicit trafficking from the perspective of China. As UNESCO stated years ago, the illicit trafficking of cultural property is the third most profitable trade in the world, following only arms and drugs. The fight against illicit trafficking is a collective responsibility that cannot be achieved by a single country or organization. It requires the concerted efforts of all nations. In this regard, the 1970 Convention and the 1995 Convention are crucial. They provide vital mechanisms for countries to jointly combat illicit trafficking and promote the return of cultural property to its country of origin. These conventions have not only established a new global legal order for this fight, but have also profoundly influenced the domestic legal frameworks of various countries. As a member state to both conventions, China's legal system and the management practices have been significantly impacted in the following three ways. First, China has actively engaged in international cooperation by signing bilateral agreements. Under the framework of 1970 Convention, China has signed agreements or MOUs with 27 countries to jointly prevent illicit trafficking and facilitate the return of cultural property. These countries include the US, Italy, Greece, Peru, Egypt, and Australia, Switzerland, etc. The MOU with the United States is particularly notable, given that the US is a major destination for illegally exported Chinese cultural objects. The MOU between our two countries is the most detailed such kind of agreement and has had a significant impact on China's practical efforts to combat illicit trafficking. This is the specific area I contributed to in this book. Second, China continuously amends and improves its domestic laws to better implement these conventions. For example, China revised its law on cultural relics protection last year. Article 81 of the revised law specifically addresses the recovery and return of lost cultural relics. It reserves the state's right to recover Chinese cultural relics lost abroad due to theft, illegal exports, or other reasons, declaring that this right is not subject to time limitations. It also stipulates that foreign cultural objects illegally imported into China must be returned in cooperation with the countries involved. based on relevant treaties, agreements, or on the principle of reciprocity. Here I want to mention that in the context of Chinese law, cultural relics is roughly equivalent to cultural properties, and movable cultural relics refers to cultural objects. So I will use these terms as needed. A third major impact is on the regulation of cultural relics trade. Chinese laws and regulations have strict provisions in this area. This can be summarized in 3 points. Point 1, the LCRP clearly defines the legal means for citizens and organizations to acquire cultural relics, such as through inheritance, donations, or purchase from qualified dealers and auction houses. It also prohibits the buying and selling of certain items, including state-owned relics, stolen cultural relics announced by the State Council, and those announced by foreign governments as lost. Point 2, China implements a qualification system allowing only licensed entities to trade in cultural relics. That are cultural relics sales entities and auction houses. These entities' operations are closely inspected by cultural relics authorities. Any other individuals or organizations are prohibited from engaging in the sale of cultural relics. It is worth noting that while these regulations are strict, we still can see items purported to be cultural relics sold in flea markets. Buyers must exercise extreme caution here, as most of them are counterfeits. In the rare case that a genuine artifact is purchased, its ownership will not legally protected due to the illegal trade, because the sellers commonly lack legal qualifications. Point 3, China has always closely managed the export of cultural relics. For example, all artworks, crafts, manuscripts, documents, books, and representative objects produced before 1949 must undergo review by one of the cultural relics import and export review agencies in major cities and obtain the export permit before they can be exported. Items produced before 1911 are prohibited from export. In contrast, the law is more lenient on imports, only requiring temporary entry declarations. This highlights China's strong stance on preventing the outflow of its cultural heritage. In conclusion, these two conventions have been instrumental in shaping China's efforts to combat illicit trafficking. They have influenced our approach to international cooperation and domestic legal reform. However, we also acknowledge that challenges remain. China still has some difficult issues to address. For instance, the management of the cultural relics market is not normalized sufficiently. and the oversight of cultural objects imports needs additional improvement. Thank you for your attention.
Thank you so much, Professor Wong. As always, your experience in this field is greatly appreciated, and I think that has raised a number of points that we may address in our Q&A, which I will now start. I noticed, and I've encouraged people to, I will be opening up the floor to questions from participants now, which I have, which I will gather and put to the panelists. Please use the Q&A function, and I see that people are quite shy, even though I've encouraged them to use the Q&A function to put questions to the panelists. So I will start and encourage people, and I realise that we don't have a lot of time. We have about 10 to 12 minutes for the Q&A. So Professor Lee, because you've had a bit of a breather starting first, I will put the first question to you. Thank you again for your broad-ranging intervention, which provided us with an important background to the key issues at stake here. And I thank you for your generosity in relation to your views in relation to the commentary. To commence our questions, I would like to focus on your work with the Intergovernmental Committee on Restitution or Return. If you could demystify the work of the committee for our participants, I would be grateful if you could explain its work and why it is important. Oh, I think we may have lost Professor Lee. Is Professor Lee still with us? No? Professor Lee has vanished. We'll wait for Professor Lee to come back. Always technology is not one's friend necessarily. So I'll throw the next question to you, Professor Cornell, and we'll try, and hopefully you won't disappear. Professor Cornell, your presentation reflects your lifetime's work over a range of international and intergovernmental bodies, stretching over many decades. Although your experience is primarily in the field of private law and private international law, a number of our participants, in fact, a lot of people working in this field will not necessarily be lawyers. And I know you touched upon this in your intervention, but if you could explain why states need to address both conventions, as you mentioned in your intervention, that's why we brought it together. But I think quite often non-lawyers don't understand why we have this distinction between public international law and private international law, and why this is particularly important in this field.
Well, traditionally, when somebody wants the cultural object back, and then the key issue is legal key issue is the ownership. Who owns the property? And the law of the location of the property is usually applicable. But when a cultural object is removed from the country of origin to a market country, and then in this market country somebody bought that object, then the law of the market country is applicable to determine who the owner is. So the mobility leads to the change of the law applicable. And the property law, from the comparative law perspective, property law is probably one of the most diverse legal institutions in the world, because it reflects the long history. In England, for instance, there are some judgments from the 15th and 14th, 15th century are still valid. So if you delve into the very long-term history of the development of the property law, then it is impossible to find a unified solution. And so the same applies to the statute of limitation. Statute of limitation, how long you can claim the return. So the creating international framework was the basis but it was soon recognized that in order to really take an action to get the cultural object back, you have to go to the court. Then the court would apply the law of the market country. And often, then the law of the market country is not necessarily helpful for the previous owner. So then the next question is, why don't we have a unified rules of the statute of limitation? As I said, to unify property law is extremely difficult. But the statute of limitation, that is rather technical, and that is doable. This is the background why 1995 convention was made. And in this context, as Professor Ii mentioned, that both conventions are complementary. I hope I give a
absolutely
answer.
And because our participants continue to be shy, you won't be challenged on that, nor will you be asked to explain further. So I'm very, very grateful, but I know that, as I said, non-lawyers quite often find that distinction very difficult, and the importance of both conventions, that the importance that the UNIDROIT Convention also be ratified so that it's effectively implemented in addressing illicit traffic. Now, we've got Professor Lee back. Professor Lee, thank you. I'm not sure whether you heard my question to you earlier.
I'm sorry, I lost the connection for the last 5 minutes.
No,
Can you?
that's
I'm sorry, but
okay.
can you repeat it?
Yes, the question is in relation to the work of the Intergovernmental Committee on Restitution and Return. If you could explain to participants what it does and why it is important.
Okay. All right. Okay. Thank you. Thank you very much for this question. Well, looks like, I think it's a very, very important question. And this question, amply demonstrates that some of the participants, maybe all the participants, were listening to this webinar, attending this webinar with great interest. Well, this has to do with the question of the so-called non-retroactivity. Right. So if you look at the 1970 convention and then the 1990 convention, so it has to do with the temporal scope of these convention. So, and if you look at the, I think it is Article 7 of the 1970 convention and Article 10 of the 1995 UNIDROIT Convention. So the temporal scope of these conventions is decided. After entry into force of the respective conventions. So, which means they do not apply the questions arising before the entry into force of these conventions, right? So that was a big question, and in that connection, I'd like to direct your attention to, I think it's paragraph 3 of the Article 10 of the 1995 UNIDROIT Convention. But anyhow, so this question of non-retroactivity, that was a very controversial point, and that's one of the reasons why, especially in the context of the 1970 Convention, to address these problems, that is address the question of return of cultural objects that were displaced before the entry into force of the 1970 Convention, that is, before 1972. These questions were taken up at the Intergovernmental Committee for the Return of Cultural Property. It's known as the committee with a long name, I think, which was launched in 1978. So again, these are very important. These two documents are very important international instruments, but at the same time, they do not directly address the question of those cultural objects displaced from the country of their origin before 1972. Okay. Yeah.
Thank you so much, Professor Lee. And I'll put the question by Professor Ian Lilly to Professor Wong because of your expertise. And I know that you have knowledge of the laws across many Asian countries, particularly Korea and also Japan, as well as China. So the question put by Professor Lily, who is also from Economos as well, is, and this is coming from an archaeologist, what are the commonalities in approaches to dealing with illicit trade which can be brought together in the region, in Asia? So what are some of the similar approaches we can talk about in relation to Asian approaches to illicit traffic or regulating the trade in cultural objects? Professor Wong? Sorry, I've called on you. I've been there, Professor Wong. So is there any similarities across the countries that our panelists in fact have been representing, so China, Korea and Japan, in addressing the regulation of movable heritage?
Well, I try to explain it in my limited language scale. Yeah. I think it's a very good question because we have a very close culture. We have a very close relationship in history. But for the issue of illicit trafficking, I think all the East countries could jointly combat the illicit trafficking closely under the framework of the 1970 Convention. However, we have some different approach dealing with this illicit trafficking. And for China, we always focus on the export. We focus on how to protect our own cultural heritage. We take ourselves as a source country, but we always we would like to cooperate with Japan and Korea because they might be one of the channel that Chinese cultural objects to be one of the objects in international marketing. So it's very important to join together, but maybe we have different ways to prevent the illicit trafficking.
Thank you very much, Professor Wong. I know it's difficult. Professor Wong has always been very modest about your language skills, and they're wonderful considering my Mandarin is 0. So Professor Wong, no, thank you very, very much for your expertise, but also your language skills. Now, there have been 2 questions in relation to the Qingdao recommendation in relation to restitution or return. I might give this, because there'll be a final question to you, Professor Cornell, to you, Professor Lee, in relation to whether Professor Wong has talked about a collaboration in relation to regulating the trade, whether there can be some cooperation in relation to restitution and return in the region. Professor Lee?
Okay. Right. Well, due to the time limit, let me just, I think there was a very specific question relating to the Qingdao recommendations, right?
Yes.
Yeah, okay. So, all right. Thank you for the question. And Qingdao recommendation, I think Qingdao recommendation is focused, I think it was adopted last year, 2024. And I think its focus is on the return of cultural property, cultural objects displaced during colonial times, right? So I think And I remember participating in the Dunhuang conference on a similar subject, which took place in 2014. So as was pointed out by Professor Wang, I think there is a growing interest in this issue, in particular, return of cultural objects to their countries of origin within China. So I think this document is a kind of building on the 2014 Dunhuang document, and at the same time it reflects a substantially growing interest in this issue within China and abroad. But if you the specific question was whether it is possible to incorporate this document into the existing 1970 convention and then 1995 convention. But at the same time, as I said to you, the 1970 both convention, 1970 convention and then 1995 convention, they are based on the principle of non-retroactivity in terms of temporal scope. So technically speaking, it'll be rather difficult to incorporate these Qingdao recommendation, because I think most of these cases that took place during the colonial times, I think they'll be time barred from the viewpoint of the 1970 convention and the 1995 convention. But at the same time, as I said to you again, I'd like to direct your attention to paragraph 3 of Article 10 of the 1995 UNIDROIT Convention. So it doesn't, this principle of non-retroactivity doesn't discourage the return of cultural property that had been displaced before the entry into force of these conventions. So let me answer this very good question, a very wonderful question that way. I'll stop there. Okay.
Thank you very much, Professor Lee. And Professor Corner, I'll need to apologise, and I'll need to apologise to the panel, to the participants who have questions that I wasn't able to put because of time to our panellists. Unfortunately, we will need to wrap up the webinar now. So I thank all three panellists, Professors Lee, Corner and Wong, for their broad-ranging discussion of our theme today on multilateral regulation of the trade in cultural objects in Asia. It is especially timely as the international community commences its updating of the Sustainable Development Goals and is focusing again on effectively addressing illicit trade in cultural goods, made more difficult now with escalating international and civil conflicts around the globe. The urgency of these issues has been made clear in regional consultations leading up to Mondia Cult, which is being held next week, and successive G20 conferences, including in South Africa this year. We are grateful to our panellists for their time and insights. Participants are reminded that the link to this video will be provided to all attendees in coming days, where you will also be able to access and read the introductory chapter to the commentary for free until the end of December, and a discount code will be available. It's not active at the moment, unfortunately, so we'll get that active for those who are interested in purchasing the commentary. Thank you again to all for joining us this evening, and thank you especially to the panellists.
Thank you.
Thank you.
Thank
Bye-bye.
you.
Good day.
Over.